Good morning and good afternoon, everyone, and welcome to today's webinar, How to Collaborate with Lawyers and Other Partners on Data Use Agreements. My name is Tom Pryor. I'm a lead senior staff attorney here at the Public Health Law Center. I'm just going to give a brief introduction to the center before we turn things over to our presenters. The Public Health Law Center is located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota, and I do want to take a moment to acknowledge the tragic violence that our community suffered this past weekend. As many of you likely know, on Saturday, Minnesota Representative Melissa Hortman and her husband were shot and killed, and State Senator John Hoffman and his wife were shot and wounded, all in a coordinated, politically motivated attack. Melissa Hortman was the Speaker Emerita of the Minnesota House of Representatives, but more importantly, she and her husband were valued fixtures in our community. Our team, pictured here, is grieving after these attacks, and the loss feels very personal for many of us. And so I want to take this opportunity in particular to say how thankful we are in this moment that we get to collaborate with so many wonderful people who work to make the world a better place through better policy, as Representative Hortman did. So thank you again for being here today, and thank you for all of the work that you do. As I mentioned, the Public Health Law Center is located in St. Paul, Minnesota. St. Paul is situated within the Bidotee region, which is part of the traditional homelands of the Dakota people. And the region is also home to the Anishinaabe and other indigenous people who continue to make countless contributions to this area. In addition to acknowledging that we sit on the homelands of these tribal communities, I also want to acknowledge that while the law has potential to do a lot of positive things, far too often it's been used as a tool of oppression and discrimination, especially against Indigenous communities and against people of color. And so a fundamental part of the work that we do as a law center is to help repair and address this heavy legacy of the law. Now, part of how we do that is by pursuing equity-focused policies that address the social determinants of health, the network of policies and factors from housing to education to the criminal justice system that impacts people's health and happiness. And by addressing those factors and the unique barriers facing different people in different communities, we can provide comprehensive health benefits for everyone. The main work that we do here at the center is providing free legal technical assistance to all communities, public health advocates, and other partners. We also publish widely on public health issues, and we offer trainings and webinars like this one. We do not, however, offer direct legal representation, nor do we lobby. If you have any questions about the work that we do here at the center, or if we can help you in any way, please do reach out to us. But in the meantime, I'm going to turn things over to my colleague, Manel, who is going to introduce herself and our other fabulous presenters today. Thank you very much.
Great. Thank you very much, Tom. Welcome, everybody. Good morning and good afternoon. My name is Manel Kappagoda, and I am a senior staff attorney at the Public Health Law Center. I will serve as your moderator and one of the speakers on today's webinar. I've worked in the field of public health law and policy for over 2 decades, and public health data sharing is one of the most complicated areas that I have worked in. Virginia Niehaus serves as Director of Regulatory and Legal Affairs for the North Carolina Department of Health and Human Services, Division of Public Health. In this role, she works on public health policy development through legislation and rulemaking, and consults on implementation and enforcement of public health statutes and rules. She also works on data sharing legal issues and oversees a team responsible for drafting and reviewing data sharing agreements. So we're delighted to have her with us today. And Carrie Wagner has more than a decade of experience in public health law and health data privacy. Carrie is currently a consultant who provides support and capacity building to public health organizations seeking to improve data and health outcomes by providing legal, technical assistance, training, and practical tools. Carrie's prior roles include serving as Regional Director of the Mid-States region at the Network for Public Health Law, one of our partners on this project, and Director of the Public Health Legal Division at the Michigan Department of Health and Human Services. This is our disclaimer. We're lawyers, so we have to have a disclaimer. The contents of this webinar should not be considered legal advice or a substitute for obtaining legal advice from an attorney who can represent you. If you have specific legal questions, we recommend that you consult with an attorney familiar with the laws of your jurisdiction. The Public Health Law Center is partnering with the Council for State and Territorial Epidemiologists in this work on public health data sharing. For those who don't know, CSTE is a national organization that works to advance public health policy and epidemiologic capacity. CSTE's members are a key audience for this project and for the work of the Public Health Law Center more broadly. And this slide just shows the components of this particular project on public health data sharing. This is today's agenda. We're going to start by reviewing some recurrent themes in public health data sharing, provide an overview of relevant laws, hear about North Carolina Department of Health and Human Services data framework, share some additional tips and resources, and then move into Q&A. To make sure that this webinar is interactive and to make sure that we're benefiting from the wisdom of the audience, I'm going to ask you to put links to any resources that you have found to be particularly helpful on public health data sharing into the chat. And you can do that now, you can do that at any time throughout the webinar. And if you also just want to put where you're from in the chat as well, that would be great, just so we have a sense of who's with us today. We held a webinar at the end of April on data sharing agreements for public health, and we asked this question: what are the pain points when it comes to public health data sharing? And our webinar audience had a lot to share in the chat in answer to this question. We noticed that 4 themes emerged. First of all, there were too many layers of internal review and approval. Second, legal review slows things down, whether the agreement involves the health department only or the health department and other parties. Third, legal and leadership may not understand public health data sharing generally. And fourth, public health staff do not always understand the reasons for and the scope of data use agreements. The purpose of today's webinar is to try and ease some of the pain that goes into interacting with your legal team related to public health data sharing issues. Now we're going to do a quick poll to see which of these 4 issues resonated the most with all of you. If there's another issue that comes up regularly for you that's different from these 4 themes, please put that information in the chat. We will use the chat to help guide us as we develop additional technical assistance resources. So we're going to give it about 20 seconds just to let people have time to answer the poll. And I can't see the chat as a presenter, but I can see that there is a lot of comments being put in the chat, which is fantastic. We appreciate it. It's pretty even. It sounds like these themes, these pain points are the common pain points, and that our audience in April was fairly representative. It looks like the leader is legal review is very slow. So hopefully the content of today's webinar is going to help a little bit with that. During our last webinar, we talked about data governance generally and where data use agreements fit into the data governance process. And the question of, is it legal to engage in data sharing, is an important question, but it's only one piece of the data governance puzzle. Data governance should consider and address the life cycle of the data your organization holds. For example, consider, how is the data collected, used, stored, analyzed, secured, disclosed, maintained, integrated with other data sets, if at all? And finally, what happens to it at the end of its useful life cycle? Is it destroyed, archived, or maintained? You'll have these considerations for each data set within your organization as well as for internal and external data sharing or integration projects. So it's a very complex ecosystem with legal considerations at various different points. And shortly, Virginia is going to talk about the approach to data governance that the North Carolina Department of Health and Human Services uses. Data governance development and implementation will involve multiple parties and roles, such as the data owner, typically in leadership, who has decision-making authority over access and use of a data set or data sets. Data stewards, the subject matter experts who work with the data and are typically responsible for implementation of at least some governance processes and procedures. The data custodian, typically IT staff, responsible for the technology used to store, transport, and dispose of data. And then, of course, there are other roles such as attorneys, privacy and security officers, and executive leadership. You may have these roles for each data set across your agency. A cross-sector data project may involve government and non-government stakeholders and agency data governance staff with these roles. Once you're at the point of drafting and finalizing legal documents, data use agreements, MOUs, there are a number of things that your attorney will be looking at when they review the documents. First, they'll want to identify the relevant state and federal laws and regulations that apply to your use case, which Carrie is going to talk about in a minute. To do so, your attorney will need to understand your program, the proposed data sharing, its goals, and so on. The Network for Public Health Law has a fantastic checklist that runs through these different elements, and we have included a link to that resource on our resource slide, which is at the end of the presentation and which you will all receive. Your attorney will also need a clear understanding of the data set or sets to be disclosed, including whether the information will be identifiable or in some other format. It can be useful to draw out data flow maps that clearly label the flow of data, including its format, between the various parties. This will help your attorney identify which laws might apply at which points in the data flows. Your attorney will then assess how the laws they identified apply to the particular use case. You might hear your attorney talk about the facts, and your attorney will then be able to help you make sure your proposed data sharing complies with the law. If the project doesn't comply with the law, then your attorney can try to help you determine if there's another way to accomplish your goals. And this is why it's so important for your attorney to be part of the larger team, as opposed to someone you go to for sign-off at the end of the project. The more your attorney understands your program and the goals of the project, the better equipped your attorney will be to help you come up with creative solutions. Your attorney should be able to help you understand the law and how it applies so that you understand how to do your work in a way that complies with the law. This is not a skill that they focus on in law school, so be patient with us and don't be afraid to ask your attorney to explain concepts clearly and in plain English. Now I'm going to turn the microphone over to Carrie to talk about the law, which she is going to do in plain English.
Thank you, Manel. All right, let me pick the right screen to share, I think. Okay. So yes, I'm going to start by giving a brief overview of some of the laws that most commonly come up now that we've talked about your attorney's role. So I'm going to give a brief overview today of these laws. And as you probably, I think, are all well aware, the law is complex, as is determining which law applies in a particular circumstance. And in a data sharing scenario, you may have federal law and state laws that apply depending on the circumstances. So what I will cover today is not a comprehensive list of the laws that may apply, just some of the most common. It's important to note that determining what laws apply to a given data sharing scenario is not a job of public health staff alone. So these determinations should be made in consultation with your attorney, with your privacy officer, and following your agency's policies and procedures. But we wanted to give this overview today to help you be able to issue spot, understand when to ask questions, generally what laws might apply, when to bring in your attorney, and so on. I do want to mention one law that I'm not covering today, but that does come up in certain contexts, and that's FERPA, which is the Family Educational Rights and Privacy Act. FERPA protects the privacy of education records, and it often comes up in the context of health departments seeking data from schools, for communicable disease outbreaks, immunizations, or oral health. And we'll share in the chat after my presentation a few resources on FERPA, as that does come up from time to time. So start with HIPAA. HIPAA was created, or was passed in 1996 and created national standards for electronic healthcare transactions. It also incorporated privacy and security protections applicable to protected health information, or PHI. So a common misconception about HIPAA is that its privacy and security protections actually follow the PHI, when in fact, the first question in the Does HIPAA Apply analysis is whether the entity that actually holds that data meets the definition of a covered entity. And covered entities under HIPAA are healthcare providers, health plans, and healthcare clearinghouses. So most health departments are covered by HIPAA because they meet the definition of a healthcare provider. They might be providing direct healthcare services or operating an FQHC, or a health plan where they're paying in some way for the cost of healthcare. And many health departments have gone through the process of designating themselves as a hybrid entity for HIPAA purposes. This is a process that involves analysis across the health department to determine which areas of the health department meet that definition of a covered entity. So that health plan or healthcare provider, or the definition of a business associate. So that might be parts of the health department that provide services to the healthcare provider or covered entity components of the health department. And so once you've gone through that process, then the health department must designate either through a policy or other documentation which programs are covered by HIPAA. And once you've done that, then you become a hybrid entity. And one of the reasons to go through this whole process is to limit HIPAA's application and your compliance obligations to only those parts of the organization that must comply with HIPAA, as opposed to the entire organization. So now I want to go through kind of a basic sample analysis of HIPAA's privacy regulations that your attorney might be assessing when determining if a health department's protected health information can be disclosed internally, say to a non-HIPAA covered component of your health department, just as an example, or externally, say to another state agency or private organization. So the purpose here is to give you an idea of how interrelated and overlapping some of HIPAA's regulations can be, and what your attorney may need to consider. So the first question is, does HIPAA apply to your program area? Again, do you meet that definition of a covered entity? And if the answer is yes, then any use or disclosure of data that meets the definition of PHI must comply with HIPAA. If the answer is no, then that doesn't mean you're just off the hook and can share the data however you choose. You need to look to other federal laws and state laws that may apply. So assuming HIPAA does apply, there are several scenarios to think through regarding whether or not PHI can be disclosed. So first is whether de-identified information is sufficient. If it is, and it's de-identified to HIPAA standard, then the information for HIPAA purposes is no longer PHI and can be disclosed. You may need to think about other laws, but for HIPAA purposes, you could disclose de-identified information. So if de-identified information, though, is not sufficient for your purposes, you may look to whether a limited data set is. Note that a limited data set can only be disclosed for certain purposes like research, public health, or healthcare operations. So it may not be an appropriate exception or use in every situation. The next thing I might look at is, does an exception to HIPAA's authorization requirement apply? So HIPAA has a general rule that to use or disclose PHI, you need to have an authorization from the individual. And then there are a number of exceptions under HIPAA that allow the use and disclosure of PHI without an authorization. An example of that is common, and many of you are probably well aware of, is the public health exception under HIPAA. Treatment, payment, healthcare operations is another common one. If none of these apply, none of these exceptions, then you may be looking at needing a HIPAA compliant authorization. So even just with this simplified analysis, you can probably see that there are many considerations when assessing how HIPAA applies and how to comply with HIPAA. And so the more information that you can give your attorney, not only about the data that you might want to disclose, but what are the purposes, who you're providing that information to, the easier and quicker that analysis may go. So I want to cover a couple of other things about HIPAA before I move on from it, and just want to make sure everyone is kind of aware of the public health exception because it so often comes up in the public health context. And so again, when I say exception, I mean that exception to the kind of general rule for an authorization under HIPAA. So HIPAA is not intended to limit or interfere with traditional public health activities such as surveillance. And HIPAA's public health exception allows a covered entity to use or disclose PHI to a public health authority. And we'll say a little bit about what that means in a moment. And the public health authority must be authorized by law to collect or receive the information for purposes, very broad purposes, so controlling disease, injury, or disability. And this includes a number of things under HIPAA and under that exception. It's really fairly broad what sort of activities might be considered public health for that purpose. Public health exception is subject to the minimum necessary rule, and I'll say a bit more about that in a moment. Now, what is a public health authority? So as you can see from the slide, it's pretty broad, includes, the federal government, a state, political subdivision, an Indian tribe that is responsible for public health as part of its official mandate. And the definition also includes entities that are acting under a grant of authority or contract from those agencies. And in addition, federal legislation has included tribal epidemiology centers in the definition of a public health authority as well. So getting back to HIPAA's minimum necessary rule, which is a rule that states when we use or disclose PHI under HIPAA, you must typically use or disclose only the minimum amount necessary for purposes of that use or disclosure. And one of the unique things about the minimum necessary in the public health exception context is that HIPAA allows a covered entity to rely on the public health authority or health department's requested disclosure of PHI as the minimum necessary. And this is in contrast to kind of the way it typically works, where a covered entity makes its own determination of what is the minimum necessary under the circumstances. And so again, this is another case where HIPAA's regulations recognize that public health authorities need the discretion to determine what they need for public health purposes, and where HIPAA was not intended to sort of limit traditional public health practice. So I want to just ask a question, put your answer in the chat here. So those of you in attendance, we'd like to know, do you rely on the public health exception when requesting data? And when you do covered entities respect your health department's assessment of what is the minimum necessary? So I'm going to keep going, but please put your answers in the chat. And the last thing I want to cover about HIPAA is its preemption standard. So preemption, is a complicated legal doctrine that really gets at whether, or allows a higher level of government to limit or eliminate the power or authority of a lower level of government to regulate on specific issues. There are several different types of preemption, and it can be a complicated topic. So if you're all thinking you have two laws that conflict, I'm not sure how or if I comply with both, you may be dealing with a preemption issue, and it's always a good idea to bring in your attorney. So for HIPAA purposes, the general rule is that if HIPAA or its regulations are contrary to a provision of state law, then HIPAA preempts that state law. And that means you would generally have to follow HIPAA and not the state law if the two conflict on the same topic. However, there are a couple of exceptions to this rule. And so for today's purposes, I want to talk about two that come up in the public health context. So first is that if state law provides greater privacy protections than HIPAA does, then state law actually controls. This comes up often around specially protected kind of subsets of information, such as HIV or behavioral health information, where states have enacted specific legislation to protect that information. The second second exception to HIPAA's preemption standard is where state law provides for the reporting of disease or injury, child abuse, birth, death, or for conducting public health surveillance, investigation, or interventions. And this includes, importantly, not only the law, but procedures established under state law. So this is an important exception that again shows HIPAA's regulations were not intended to limit public health activities. So the next federal law that I want to just touch on briefly is 42 CFR Part 2. And these are federal confidentiality regulations around substance use disorder data. And this is an example of where HIPAA and another federal privacy law coexist. We apply principles of statutory interpretation, and in general, a more specific law will apply over a more general one. And Part 2 is very specific about the confidentiality of substance use disorder data. So HIPAA may also apply generally. Typically, your attorney may be looking at compliance, how they can comply with both laws. But in terms of Part 2, it provides special protection for SUD treatment records in order to try to combat the stigma and fear that patients might feel, especially regarding that their disclosures to their providers might be used against them or disclosed without their consent to law enforcement in particular. And so Part 2 was really seeking to try to encourage people to seek treatment without fear of exactly that stigma and that their information might be used against them. It's important to know, though, that Part 2 only applies to entities that meet the definition of a Part 2 program. And that's in a simplified basis is certain federally assisted programs. Common examples are opioid treatment centers or residential or outpatient treatment programs that are federally assisted. I can say from experience, back in my days working for a health department, what meets the definition of a Part 2 entity is not always easy or straightforward. So certainly bring in your attorney if you have any questions. I won't spend a lot of time on this slide in the interest of time, but I do just want to make sure everyone's aware that last year SAMHSA issued a final rule on Part 2 that brings its regulations more in alignment with HIPAA. On the slide, it's not an exhaustive list of changes to Part 2. I'm really just highlighting those of interest here that may be or enable greater data sharing among covered entities under HIPAA and Part 2 programs, as well as public health. And there's a resource from the Network for Public Health Law as well that goes into those changes. So while not a privacy rule per se, the Federal Common Rule sets out ethical and other principles for human subjects research and may need to be complied with in addition to other federal, state, or confidentiality laws, including HIPAA. The Common Rule includes requirements for institutional review boards, informed consent, and assurances of compliance. So you may need to comply with both HIPAA and the Common Rule in some circumstances. For example, if in the research context, you may need informed consent under the Common Rule and a HIPAA compliant authorization if part of the research will access protected health information. And you may also need to comply with HIPAA's privacy protections applicable to research activities in addition to the Common Rule. So the content on this slide comes from UC San Francisco, which has a resource explaining the difference between research and public health surveillance activities, which a line that can often be blurry. The main difference from the example on this slide is that in the public health surveillance example, that the purpose is not only to identify the prevalence of tobacco use, but to assist in developing proper control measures or public health interventions. So once, in addition to federal law, state privacy laws also need to be taken into account. And those, of course, will vary across jurisdictions. And the important thing here is to be able to, identify when you might be dealing with a state privacy law, when it might apply to the data that you'd like to use or disclose. Again, important to work with your attorney, and our aim today is really just to help you identify those questions. On the slide, types of information and where state privacy laws are often in effect are around certain subsets of information, such as HIV, immunization registry information, communicable disease, behavioral health, and so forth. And while I had some examples that I kind of had teed up to go over, I think in the interest of time, I want to kind of wrap up and turn it over to Virginia to tell us about North Carolina's experience. So I'll end now with a poll. We want to get a sense of how familiar you are with the laws in your jurisdiction that govern data sharing. Thank you. That's interesting. It's always interesting to see how, where people are in terms of their knowledge. All right. So with that, Virginia, I will turn it over to you.
Thanks, Carrie. Hi, everyone. I'm Virginia Niehaus. I am the Director of Regulatory and Legal Affairs for the North Carolina Department of Health and Human Services Division of Public Health, which is the state health department in North Carolina. Our division is one component of a DHHS super agency here in North Carolina, which manages the delivery of health and human-related services to all North Carolinians. And then within my office, within the Division of Public Health, one of our functions is to review and facilitate public health data sharing requests. And so this afternoon, I'm really pleased to be here with you to talk about one of my favorite topics, which is data sharing, and to share with you some of our department's efforts to develop and launch a department-wide data sharing framework. I very proudly and happily contributed to the development of pieces of this framework that I'm going to talk about, but from the start, I just want to acknowledge and recognize the many people across our department and in our data office who have led, contributed to, and supported these efforts. In this presentation, I'm going to be speaking about the framework from my perspective and sharing some of my own experiences. If you'll go to the next slide. Thanks. So when I joined the Division of Public Health, which was back in about 2018, there was somewhat of a fragmented approach to data sharing across our department with a lot of variance in policies and processes and procedures. But in 2019, our department established a centralized data office to begin driving department-wide approach to data sharing. We actually entered into a contract with the Actionable Intelligence for Social Policy Group at UPenn to assist us with an effort to transform our department's collection, governance, and use of data. And through this process, we established a data strategy that's based on 5 pillars that you'll see here on the slide: data governance, data infrastructure, data quality, data literacy, and data use. Launching this framework required a lot of participation and partnership from across our department. It brought together data teams and privacy and security teams, legal teams, technology teams, program staff, and leadership all together around this effort. We'll go to the next slide. I'm going to focus in particular on the data governance piece of those pillars, and there have been 4 main efforts in this space. The first was the establishment of a data governance organization to enable shared decision-making about strategic data use and data strategy development. The second was the creation of a data sharing guidebook and a data sharing legal framework to outline clear and consistent processes and policies that streamline data sharing across our department. Third, we documented key data assets across our department to make our data more discoverable and accessible. And then finally, and this work continues ongoing, is the establishment of data standards that allow for consistent and uniform collection and use of data. Of these efforts, I'm going to again focus in more narrowly on the data sharing piece of that. If you'll go to the next slide. The North Carolina Department of Health and Human Services data sharing guidebook, which you'll see here on this slide, and which I believe Stephanie may have popped a link to in the chat. It is a publicly available resource, but one that was developed to establish clear processes for data sharing, both within our department, interdepartmentally between divisions and offices, and with external partners. It aims to better use data as a strategic asset, aligning with our department's missions and goals to improve health, safety, and well-being of all North Carolinians. The guidebook establishes clear pathways for data sharing and integration, outlining pathways for many routine use cases, such as data requests to support operational purposes and data requests for research. It clarifies processes for data sharing with the aim of reducing burden and increasing efficiency, while also making sure that we meet our legal requirements and are safeguarding the privacy and the security of our data. It outlines the roles of staff in the data request process, including the role of a data owner who has legal authority over the data and is the decision maker, data stewards, who are the folks who are working in that data day to day. They are the experts in the data and they're responsible for the governance of that data. Data custodians, who serve as handlers of the data, overseeing transport, storage, and disposition, as well as support roles for legal counsel, privacy and security officers, and others. The guidebook addresses many specific data sharing topics, including legal considerations, relevant statutes and rules, de-identification standards, as well as data transfer and storage. And it's a really helpful resource, both for our staff and for the partners that we engage with. It's a living document that's reviewed and updated annually. It kicked off in 2021, and we're now working on a 2025 iteration. And again, it's posted publicly and available to anyone who has an interest. If you'll go to the next slide. So in addition to clarifying data sharing processes, there was a need to establish a legal framework to better facilitate intradepartmental data sharing, that is, sharing from one component of our department to another. Our agency as a whole holds a lot of data, and it's often siloed within individual divisions and offices. Within the Division of Public Health, we hold many data sources, including communicable disease data, cancer registry data, vital records data, just to name a few. And within each of these divisions and offices, there are unique and distinct data systems that collect data from various sources under a patchwork of specific state and federal laws that apply to them. And so from my perspective as an attorney navigating that, this raises concerns about what the law allows, as well as accountability for sensitive data that's flowing, including how it's used, disclosed, secured, and destroyed once a project is completed. Prior to the establishment of our framework, this legal framework you see here, the assessment of these requests was really done on a case-by-case basis, and it often led to interdepartmental data sharing agreements, and was a bit time-consuming and could be a little inconsistent in its application. To address these, we rolled out this legal framework, which is comprised of 3 foundational agreements, which you'll see on the slide. With the intent being to make it easier to share data between our divisions and offices, to leverage it as a strategic asset, as well as to respond to data requests requiring data from multiple divisions and offices, integrating data, especially to answer key strategic questions. So the first agreement that you see on this slide is the Interdepartmental Memorandum of Understanding, or IMOU. This is a non-binding document, and at its essence, this was a common agreement among divisions and offices to agree, to engage in the framework, to create buy-in in the framework, and it references all of the other components of the framework, including the 2 other agreements that are on the slide, as well as the data sharing guidebook that I just spoke about, and it's signed by all of the divisions and offices as they enter into this collaboration. The second agreement is a data sharing agreement, or DSA, and this is an agreement that each individual division or office executes that sets out that division or office's particular data assets, the laws and restrictions that apply to their particular data assets, and the terms and conditions governing the use, transfer, storage, and management of those data assets. And it's essentially the agreement that governs the way that a division or office's listed data assets that are in that agreement may be used by other components of our department. And the last is a data use agreement template that may be used in cases where there are additional terms that might be needed to govern a particular data, like particularly sensitive data asset or for a particular project, including sharing sensitive data with external partners. But internally, this has really become the exception and not the norm, as most of our data sharing can be accomplished under our data sharing agreements. The diagram that's there on the left part of the slide is sort of a visualization of how all of these agreements work together. The IMOU in the middle sort of connects us all together. The rules of the road, the rules of the sandbox. The DSA for each division or office sets out the specific terms for the data assets within that division or office, and how they may be used by other components of the department through the data request process that's outlined in the data sharing guidebook. And then for those certain occasions where DUA is needed, you see the connection point there. And as you might imagine, there are a number of data stakeholders as well as lawyers in our department. And so it really took some time to sort of work through these legal agreements, come to agreement on the terms of these foundational agreements. And they continue to be revisited and improvements be made as agreement terms come up. We'll go to the next slide. This next slide shows the data request process that is set out in the data sharing guidebook. At the top of the slide is from the perspective of the data requester. And I think it can be helpful just to like flow out how things are moving through processes. So it starts with planning, and I think planning out what you're seeking, the purpose of your use case, and getting people involved early. And you'll hear me say that a few times. It is really helpful to the review and flow process. After sort of like planning what the request looks like, making that request, and in our framework, this often looks like filling out one of several data request forms based on the purpose. We have a few different sort of established pathways and forms that go with those pathways, which allows for quicker categorization and review of those requests. Then there's a determination of what's needed to grant access, whether it's permissible under the terms of the existing DSA, or whether a more specific GUA might be needed. And then once received, the requester analyzes that data, makes use of it, and then there's a destruction plan that follows the destruction guidelines. The bottom is the process for receiving and reviewing of a request. So what it looks like for our data office to take in and look at a request. The request is submitted, as I said earlier, often in the form of a specific form to the data office, which reviews the data source that's requested and the purpose, and looks at whether it fits within the data sharing agreement. And as part of their review process, they ask three key questions. Is this data sharing legal? Is it ethical? And is it a good idea? And these are answered in consultation with legal counsel and with data stewards and data owners through a consultation process. Data steward and data owner are two of the roles that are set out in our guidebook in terms of like the folks who work most closely with this data and are responsible for the governance, and the folks who have legal authority over it. Because in addition to legal permissibility, it's really critical to determine whether the request is feasible and whether the data requested is appropriate for the use case. And then finally, the data office has a process for tracking the fulfillment of requests and any stipulations on the approval of the request. You'll go to the next slide. This has had a big impact on our department. It's really fostered a positive data culture, including building trust, encouraging cross-departmental collaboration, promoting data-centric mindsets. It's gone a long way to clarify roles and policies and processes to streamline and make our process more efficient. And it's created a really strong foundation to support data sharing in our department and allow us to better leverage data to improve services and outcomes within legal requirements and within privacy and security safeguards. I've been personally a big fan of how this has worked. In my experience, it's made data sharing within our department much less cumbersome and more straightforward, and also streamlined processes for working with external partners. I was reflecting on some of the pain points that Manel was mentioning at the beginning of this presentation, and I really think that it's gone a long way to remove layers or decrease layers of review, to ease the burden of review, and the drafting of agreements, which can sometimes slow down legal review and negotiation, and created really a common understanding of our data sharing framework and the agreement process. We'll go to the next slide. My last few slides focus on the role of legal counsel in supporting data requests. This slide outlines the role as articulated in the guidebook, which you can refer back to, but really focuses on researching and advising on laws that impact data access and use, drafting, reviewing, negotiating agreements, reviewing data requests to determine what is permitted and what's needed to facilitate access, as well as working with privacy and security officers to mitigate risks and respond to incidents and breaches. Speaking from my own experience, when approaching your legal team regarding a data request, I really recommend engaging your attorney early, making them part of the team, including them early in your process, allowing plenty of time to explain your request, and for the legal review of the request to take place, and for drafting and negotiation of agreements if needed. And that's especially true if you have like a deadline lingering out there, such as a grant deliverable, trying to get early with your legal team. Being prepared with documentation to support your request, and I'll talk a little bit more about that on my next slide. Fully open and transparent about what is being requested and how it will be used and responsive to the questions that are asked. And finally, when interacting with your attorney, I recommend assuming good intent. They want to help you. In my work on data sharing, I try to find a pathway to yes, I try to be creative in the way that I think about data sharing, but it may not always be possible. And there may be reasons for that. So it's important to sort of like listen and ask questions of your attorney to understand their reasoning. Keeping in mind that your attorney likely has a lot of competing priorities and is being pulled in a lot of directions, so be patient with them. That they may not have expertise in public health or in data sharing, so share your resources, share your expertise. I think that's helpful. And just keep in mind that they want to help you. You'll go to the next slide. And then from my experience, here are a few tips that I often give to data requesters. Before requesting data, connect with the people closest to that data that you are seeking to better understand what is available and feasible and understand the limitations of the data that you're requesting. Once again, engage your legal counsel early, allowing time for review and any legal agreements. Be prepared with and provide documentation that will help data staff and legal counsels and others who are facilitating the request to better assist. This includes a description of the use case or the purpose of the request, the requested data source and data output, including the fields that are being requested, whether it's line level or aggregated, whether it's identified or de-identified, whether you're planning to link it or integrate it with other sources. A data flow diagram, which I think Manel also mentioned this piece earlier, that shows who will receive the data. And this is especially true if there are multiple partners involved, or if there's going to be downstream sharing of the data into something like a pooled analytic data set or into a registry. And then if it's research, to have your IRB approval and your approved protocol, and to ensure your use case lines up with your IRB approved documents. Our agency uses forms to capture a lot of this information, which is a really efficient and standardized way to approach this. All of these factors, use case, recipient, data source, level of output, are things that your legal counsel will need to know to assess the legal framework, permissibility of the use case and the data sharing process, as well as determine what, if any, legal agreements are going to be needed. And remember to explain your project in plain language. I try to speak in plain language when I'm speaking to folks about my legal reasoning, but also know that we are often non-scientists and may need you to break it down for us into plain language. And with regards to confidential data, ask for only what you need for your use case and support that with your documentation, and in the case of research, with your IRB approval. And this is a concept known as data minimization, under the concept of using the minimum necessary in the confidential space. And finally, to the extent you can, become familiar with your legal frameworks. This webinar is a great step towards that. Carrie offered a lot of pertinent information, but there's also a lot at the state and jurisdiction level, and I recommend proactively reaching out to your legal counsel to understand the laws that apply. Thank you so much for having me. I'm going to transition things over to Manel.
Great. Thank you. Thank you so much, Virginia. That was terrific. I love the book. I have it printed out. I've got it highlighted, and I've got sticky notes all over it. It's on my desk. It's just a fantastic resource for the field. And
Manel, you're sharing your notes screen, just so you know.
Oh, that is not what I want to do. Hang on one second. Get sorted out. Thank you, Stephanie.
No problem.
But yeah, it's just a fantastic resource for the field. Let me try and get the right. Let me see if that's better. Is that, have I done it?
Yes, that is perfect.
Got the right screen. Fantastic.
Yes, you're good.
Before we move into our final content for the webinar, I do want to give Carrie the opportunity just to provide an example of a state law, because I think that both from what Virginia was saying and then from the poll that we did at the beginning of the webinar, folks aren't always totally clear on how the different laws interact with each other and what state laws say. And so I think it might be helpful to just have a quick example.
Sure, I would be happy to. I was clocking in overtime when I practiced, so felt like I needed to move along.
It was great.
But as I mentioned in my presentation on the state law side, it tends to be, like specially protected subsets of information as opposed to, applying to, well, I guess it's not a one size fits all, I was going to say, as opposed to applying to like all health records, but there are Medical Record Privacy Act, and increasingly states are adopting Consumer Protection Acts, which may or may not apply to public health, but certainly could impact how you collect information. But in the context of kind of what I was presenting on, HIV is an example where states often have legislated and provided special protections for that type of information. And so I'm from Michigan. I'll use a few Michigan examples, and not all, but a few. So in Michigan, we have a law around HIV confidentiality that makes all reports, records, and data pertaining to HIV and AIDS confidential, and says that information can only be released in accordance with specific and pretty limited exceptions. So the law limits how and when information can be disclosed in response to a court order. And it also limits disclosures to state and local health departments and healthcare providers to only a few purposes: protecting the health of an individual, preventing further transmission of HIV, and diagnosing and caring for a patient. So, and that's a case where you may have HIPAA applying, but then when you're looking at the preemption standard, does the HIV Michigan law go further? And maybe we need to comply with that when it comes to HIV related information. In the case of immunization information, so Texas has one of the stricter IIS confidentiality laws that I'm aware of. Consent is generally required for information to be included in their immunization registry. And information that's received and identifies an individual is typically confidential and may be used by the Texas Department of Health and Human Services only for registry purposes. Limits the information that can be used, so that it's not subject to subpoena or admissible in a civil, administrative, or criminal proceeding. So it's not an exhaustive kind of list of the confidentiality requirements around IIS information in Texas, but as you can see, certainly one you would want to be aware of. Communicable disease, again, I'll give another Michigan example. We have an administrative rule here in Michigan that states that medical and epidemiological information that identifies an individual and is gathered in connection with a communicable disease investigation is confidential. So what does identify an individual mean? For HIPAA purposes, there's de-identification standards. There are pros and cons and flaws to that, but where it just says, and I know a lot of state laws at times say, information just may not identify an individual. What exactly does that mean? What's the level of risk you have to determine? Those are the kinds of things your attorney will be thinking about. In addition, in Michigan, the law, communicable disease information is not open to public inspection without an individual's consent. What does open to public inspection mean? That I think that is open to some interpretation. And so just all that to say that, in these examples that there's a little bit less of a framework typically at the state level than there is, say, with HIPAA. But there are certainly still things to work through that your attorney will be thinking about, kind of as I was just mentioning. So appreciate the opportunity, Mel. Thanks.
Great. Thank you, Carrie. I think that's important just to highlight the complexity of the issues around public health data sharing. So we are going to wrap things up. We've got about 5 minutes left. The panelists can stay on for a few minutes after. So if other folks can stay on and have questions, we're happy to continue until 5 after or so. I would love to hear, to see in the chat what strategies you all have used to develop productive working relationships with your attorneys. So if you can put anything in the chat that you think would be helpful for other folks on the webinar, we'd love to hear from you about that. We often get the question, are my conversations with my attorney confidential? And generally, conversations between a client and their attorney are confidential, and we strongly recommend you talk to your attorney about how to preserve attorney-client privilege. We did get questions from several audience members before the webinar about working with tribes, data sharing for tribes, and for tribal epidemiology centers. So I wanted to just flag that we've included a list of resources in the slide deck that are specific to public health data sharing for tribes. We've also responded to several technical assistance requests in the course of this project from tribal epidemiology centers. So if folks have specific questions, please reach out to us directly, and we'd be happy to support you on those questions. And we also know that there are many jurisdictions that don't have access to attorneys or to public health attorneys specifically, and got several questions from the registration about this issue. I wanted to just highlight that all of the organizations on this slide do provide either general public health law, technical assistance, or technical assistance specifically related to public health data sharing. And again, this will be part of the slide deck, and there are links to the organization's websites in the deck. And then we've ended with just some general resources. So I'm going to in the last couple of minutes that we have, I'm going to move us into the Q&A. Thanks to everybody who has joined us on this webinar. Really appreciate it. Appreciate the engagement in the chat and the questions. I'm going to start with a question for Virginia. And this is a question that came up from folks that registered and also has come up for us on our technical assistance that we've been doing during the course of this project. Are HIPAA covered programs within a health department allowed to share protected health information with non-HIPAA covered programs within their health department?
Thanks, Manel. And I'm going to give a sort of lawyerly answer to that question, which is it depends. And I expect Carrie would answer that question similarly. But it may depend on the particular use case, on the source and the granularity of the data that's being shared, and the legal framework that may apply. There may be particular laws in your jurisdiction or state that allow for data sharing for certain purposes, like public health data sharing. We actually deal with this sometimes within our health department when we are a hybrid entity within our Division of Public Health in North Carolina, and there may be a request from our communicable disease group, from our state laboratory for public health, which is covered by HIPAA in many respects for certain data. And so there are ways to document and navigate those types of situations, but I recommend reaching out to your legal counsel to discuss it.
Great. Thank you, Virginia. And appreciate that, and also appreciate that you managed to keep us on time. So we are going to officially end the webinar here because we have reached the end of our hour. But like I said, if folks have questions and want to stay on, we are happy to stay on, and we'll do a few more minutes of just Q&A. And I am going to stop sharing here so that I can see what questions are in the chat.
There's a,
Um,
there's a few North Carolina specific questions in the Q&A.
yeah, do you
Um,
mind tackling those, Virginia?
Yeah, I'd be happy to take these up briefly. So Darlene is asking what sorts of changes we've been making to our guide in our annual review. And I was searching my memory. I think it's become less in recent years, but we've definitely learned as we've implemented. Some of the things that we've done is build on to our data governance structure, our data governance organization with regards to our executive board and our data governance council and the functions of those decision-making groups, as well as to sort of build out more the roles and involvement of data stewards, the folks who are closest to the data, and being able to build in their perspectives and establish work groups for them to come together and share and learn and inform. Um, and then we've also made some updates to our forms. So like as we've tested out these pathways that we've established for data sharing, we've definitely made tweaks to it, to the information that we're gathering, to the review processes to make it more streamlined and efficient. So those are a few examples. And let me get back to the Q&A. What was the time frame to work through this framework and the legal agreements? Our work really started in earnest in 2019. The first iteration of the guidebook came out in 2021. So it took a few years for us to work through to really take a lay of the land, because that was the first thing that they did. And as part of this process, and then to develop these documents. But I will say this overlapped with COVID years. So the time frame will look different for every agency and may depend on what else is happening in public health at the time. And Amanda asked, is North Carolina centralized or decentralized as a public health state? We are decentralized. We do have 86 local health departments. They are not part of the legal framework that I talked about, but we do, when needed, put DUAs in place with local health departments. And these documents that I talked about are really like internal to our department, this legal framework. But divisions and offices do have an opportunity to redline and provide input on their DSAs, so long as it's consistent with our overall data framework. And then Christopher asked, kind of the scope of this framework. So the aim of the legal framework that I talked about was really to help us move data within our department, to be able to leverage data assets in different parts of our department to answer key strategic questions, and also to facilitate integrating data from multiple divisions and offices to be able to answer questions and to facilitate requests from partners. But it does have a component that assists us with external data sharing.
Sorry, keep going, Virginia.
And then I think that the last question that Esther just dropped in was regarding tracking. And there's actually in the data guidebook, there's a data flow that talks about how we track operational data requests. And one of the tools that we use is ServiceNow.
Great. I am just going to just put my email in the chat for folks. I think there is another question at the beginning about a law enforcement agency, and that is a little bit more specific. But as Tom said at the beginning of the presentation, we are providing sort of more detailed technical assistance responses to questions that are coming up. And so I put that question in this category. And if Christopher, you want to follow up with us directly, we would be happy to have you do that and either set up a call or respond in an email. So I think with that, and that actually, I should say goes for anyone else who has any other questions, or if you submitted a question with your registration that we didn't touch on today, please feel free to follow up with me directly. I think with that, we are going to wrap up. I want to say such a big thank you to Virginia for doing such an excellent job of explaining North Carolina's work in this space. And I want to thank all of you for joining us today.